Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss the point whether the granting of bail depends on the accused to be handed over for judicial custody or for police remand. Is it necessary? So Supreme Court clearly said it's not necessary. You all know that granting of bail is the personal discretion of the judge. At the same time, there are certain guidelines to be followed. That's all. Not the need for custodial trial will become one of the impediments for granting the bail. This is what is stated by the bench of two judges, bench of Honorable Supreme Court of India, Justice M.R. Shah and Justice Hima Kohli, in the case of X versus State of Karnataka in Criminal-Appeal number 1981 by 2022 on 17/11/2022. So, in which they observed that the need of custodial trial is not at all relevant. So, therefore, they set aside the bail granted to the accused. So this is a reverse issue. You will understand why I have stated that the already granted bail was rejected by the Supreme Court. Now, the important points, before considering the important points, let us go to the details of the case. This case was registered as crime number 8 by 2022 under sections 376, 354, 323 read with 120B of the IPC of Lakshmipuram PS, Mysore city in Karnataka state. Of course, in this case, the allegations are that the victim was given juice mixed with some substance, due to which she actually lost control over herself, and ultimately in that situation the accused person assaulted her sexually, right? And that too, the FIR was registered after 5 days. This is the observation of the High Court. High Court ordered that the FIR was filed after 5 days. Allegation that the accused mixed some substance in the drinks and offered her, as a result of which the victim became unconscious, and taking advantage of the same, the accused committed the sexual assault. No doubt, the accused was arrested on 11/2/2022 and actually he is in jail. Therefore, thereafter, he filed a petition for grant of bail under section 439 CRPC. 438 is for anticipatory bail. 439 CRPC is for granting bail to the persons who are already in custody. Now he has filed a petition to grant bail. Okay, and High Court, they have taken the matter into consideration and thinking that since already the charge sheet has been filed and since there is no need for custodial trial, they have granted bail because of the 5 days delay and other things. Now Supreme Court said, what are the relevant points to consider for giving bail or not? Number one, seriousness of the offence. Whether it is a murder, if so, murder by so many persons, or murder for gain, or murder and burying the dead body, like that. Rape and murder, seriousness of the offence, they have to know. Second is the material collected during the investigation. How far the investigation was done? Is there any necessity to probe further? If though, is there necessity for the accused person? And how many witnesses have been examined, and what are the statements of the prosecution witnesses, whether the case can be relied or not? These points they have to take into consideration, but not the point. The High Court failed to note that the allegations in the FIR are very serious. Simply saying that there is no need for custodial interrogation, the High Court should not have granted bail to him, because the allegation is very serious. She was given some seducting dose and she was compelled to give consent. So please remember, the point for consultation is the victim went to the government hospital and they asked the local police to come. The local police came, recorded, but they did not register a case. So this has to be taken into note of by the Honorable High Court, but which it did not do. So simply saying that no custodial interrogation or no need for a custodial trial, they cannot give bail. They have to take all the facts into consideration and then only come to a decision. Right? So therefore, now bail order is already, the bail order which was given by the High Court is set aside. But at the same time, High Court is directed to take up the petition afresh, basing on the facts of the case and decide the bail application once again. Very good judgment by the Honorable Supreme Court of India. Please read it and enrich your legal knowledge. Thank you very much.